Everyone, thank you for coming out this evening. I'm Kyle Cleveland with TUJ's Institute of Contemporary Asian Studies. The panel we have tonight is on sex crimes and criminal justice in Japan. And this is always a timely issue, but as we know in recent months, the Me Too movement and issues about sexual harassment and rape culture and all of those issues have come to the forefront, certainly in Western media, not as much in Japan. But one of the principal figures that has brought this to more public attention is Shiori Ito, a young freelance journalist who had experienced sexual harassment and rape. And as she tried to deal with that through the Japanese criminal justice system, she had great difficulties and her claims were not initially acknowledged. I encourage you to go up on YouTube. You can see a number of her talks on the Foreign Correspondents Club of Japan website, FCCJ YouTube channel. They have a long lecture by her about those issues. This panel is being brought to us really by Miyazawa Setsuo, who is teaching at the undergraduate program this semester, but has been involved with issues related to international law and Japanese law for many, many years. By an odd coincidence, when I first came to Japan in 1990, my senpai Bob Kidder, who is a sociologist from Philadelphia, Temple's main campus, had worked closely doing ethnographic research with Miyazawa sensei. And I don't really even have time to read all of his accomplishments. He's taught at Harvard, UC Berkeley, UC Hastings, and most importantly, Temple University, Japan. And he has brought a couple of his former students, Mari Hirayama and Hiroko Goto. Hirayama is a professor of law at Hakuoh University, and Goto-san is professor of law at Chiba University Law School. They've both been involved in the very specific legal process of dealing with this, and I think they'll bring a lot of insight into the criminal justice system that we probably would not otherwise be aware. So they will speak for about 20 minutes each, and then we'll have an open Q&A, and don't be shy about speaking. When we do have that open Q&A, we ask everyone to come up to this microphone when they ask their questions. Okay, so Miyazawa.
Okay, yeah, thank you very much for giving me this opportunity to speak with two great female criminologists in Japan. And they will discuss details of substantive issues. And I will simply provide institutional backgrounds to provide basic information about the criminal justice related to the recent incidents. And okay, I'd like to start from the institution called Inquest of Prosecution. But in order to discuss it, I have to start with, with the power of prosecutors in Japan. They monopolize power of prosecution in Japan. Nobody else can prosecute anyone in the Japanese court, except in a very limited opportunities, which I will discuss later. And prosecutors has enormous discretionary power to decide whether to prosecute the suspect or not. And they can drop prosecution for the reason of lack of evidence or insufficient evidence. And the reason of insufficient evidence was in the case of Ms. Ito's case. And also prosecutors may so-called suspend prosecution, even if they believe that the suspect is guilty. If it's not necessary to send the suspect to prison, considering the character, age, environment of his or her upbringing, and gravity of the offense, and the situation when the crime was committed, and the circumstances after the offense, for instance, whether the compensation was made or not. So the prosecutor has enormous discretionary power. And in 2016, nearly 60% of cases were handled by so-called suspended prosecution. So the term may give you an impression that sometime in the future, prosecutor may reopen the case and decide to prosecute the suspect. But virtually, there will be no such occasion to reopen the investigation. And also, about 6% of suspects received the decision of non-prosecution for other reasons, including no evidence or insufficient evidence. And Ms. Ito's case was one of this category. And obviously, more serious cases has lower, smaller rate of suspended prosecution. For murder case, only about 4% received suspended prosecution. And in rape cases, only about 4.5% of suspects received suspended prosecution. But the proportion of cases that received non-prosecution for other reasons was very big. In murder case, it was 63%, and in rape case, it was 55%. And the reasons are similar. Police and prosecutors found no evidence or insufficient evidence, or particularly in case of a rape investigation, a complaint may have been withdrawn. So in such situations, prosecution may be dropped other than suspended prosecution. So how should we consider this situation? I believe that restrained prosecution is not a bad thing, because it's a criminologist common understanding that punishment will not rehabilitate people. Punishment will simply worsen the situation of the defendant. Therefore, I think restrained prosecution is not a bad thing in principle. However, prosecutors may drop prosecution or suspend prosecution for unjustifiable considerations. For instance, a political consideration. That is the alleged motivation for prosecutor to drop prosecution in Ms. Ito's case. And also, in such situations, victims, bereaved family, complainant, or accusers may be quite dissatisfied. Therefore, two systems of remedies were introduced in the late 1940s as a part of post-war reforms, post-war democratization of the political system in Japan. One system is called quasi-prosecution procedure, weird English translation, but this is official translation of the Japanese term. And this procedure applies to crimes involving abuse of power by a government employee, most typically police officers or prison guards. Okay? And the complainant or accuser may ask the district court to examine the case and prosecute the defendant. If the court determines that way, then a practicing attorney will be appointed as a designated prosecutor. Last year, in 2016, I'm talking about the statistics taken from the most recent version of white paper on crime in Japan. In 2016, there were about 400 such complaints filed at the various district courts, but no person was prosecuted through this system. Actually, in the entire post-war period, there were only 21 finalized cases based on this procedure, and only 9 convictions were made. So this procedure is very difficult to use for most people. Then we are finally coming to the inquest of prosecution. Every district court and their branch courts have committee called Committee of the Inquest of Prosecution. In the United States, grand jury determines whether to prosecute the defendant. But in Japan, that idea was rejected during the post-war reform. Instead, the Japanese government introduced this system. the Committee of the Inquest of Prosecution reviews prosecutor's decision not to prosecute the suspect. And this applies to any kind of crime. The previous one, first system, was limited to abuse of power by government employees, but this procedure applies to any crime. And the committee can decide in 3 different ways. Non-prosecution was appropriate, non-prosecution was inappropriate, and prosecution was appropriate. In order to make the last third decision, they need 8 votes or more from among 11 members. Every committee has 11 members who are randomly selected from local voters who are older than 20 years old. And this committee's decision used to be non-binding, but based on the recommendation by the Justice System Reform Council in 2001, the third type of decision became binding. So first, the committee returned the decision that prosecution was appropriate. Then the district prosecutor's office may refuse to reopen the case. Then the committee may decide again that prosecution was appropriate with 8 or more votes. Then the court will order the prosecution of the suspect. And like in the previous system, prosecuting attorney will be appointed as designated prosecutor. In 2016, there were more than 200 such applications, complaints, but only 3 cases reached compulsory prosecutions. So compared to the previous one, this is available for any kind of crime, and also success rate is slightly higher than the previous one. And since the introduction of this system in 2009, introduction of the binding force of the decision of the committee, 7 cases reached final decision. And among those 7 cases, 2 were convicted. Okay. And most recent case involved 3 former top executives of TEPCO, Tokyo Electric and Power Company. They were charged with professional negligence, causing death or injuries by the meltdown of the Fukushima Daiichi nuclear power plant. And this procedure has been so far limited mostly to defendants with some sort of power, like the vice police station chief, former top executives of JR West, and a Diet member, Ichiro Ozawa. But I see fundamental problems with this system. The system has no limitations regarding applicable crimes and suspects. Okay? And also, procedure is completely closed. So the targeted person has no opportunity to defend himself or herself. Okay? And so I have a fundamental question about the appropriateness to force the target person to face the risk of prosecution again. You know, this, if you are a lawyer, American lawyer, concept of double jeopardy will be is familiar. But you know, Japan does not have a strong sense about that concept. So I think this is a fundamental problem of this system. And there was a case called Kabutoyama case about 40 years ago near Kobe, where Hirayama-san lived. And she was charged with murder. With the defendant was charged with 2 murders on the basis of a decision by the committee of inquest, although it was not binding. Prosecutors waited for that decision to reopen the case. Prosecutor really wanted to reopen the investigation. And she had to fight for 20 years to finally get acquittal in the entire judicial system. So I'm very much, I should say, very much worried about that possibility from that system. Okay, then next one is a very famous one, lay judge system. This was introduced in 2009 to promote public understanding and improve public trust in judicial system. And this system applies to crimes punishable by death or indefinite imprisonment, or committed with intent that resulted in the death of the victim, which is considered to be about 2 to 3% of criminal trials in Japan. And in 2016, there were about 1,000 new defendants who were put to this system, out of about 87,000 cases, defendants sent to for formal trials. Okay, and those cases are decided by mixed panel at the district court. Mixed panel include 3 professional judges and 6 lay judges. Lay judge is called saibain in Japanese, and official English translation also is saibain somehow. And the Japanese government has been consistently using that term. Okay, and in uncontested cases, the panel may have only 1 professional judge and 4 lay judges. But I don't think there has been any such case so far in Japan. And the lay judges are randomly appointed from local voters who are over 20 years old on a case-by-case basis. And every fall, the court will prepare a list by lottery. And then for each case, again with a lottery, the court will summon a certain number of people, okay, to the court. And they may decline on various reasons. And both prosecution and defense has 4 peremptory challenges. And in the end, 6 lay judges and 2 alternatives will be selected. So the courtroom looks like this. Chief judge and 2 judges and 3 lay judges and the defense attorney and the prosecutor. Okay. And the defendant has no right to choose a bench trial because this is not a constitutional right, like right to jury trial in the United States. So every trial of the specific categories of cases are supposed to be tried this way. And professional judges interpret law and procedure. And the fact-finding and the sentencing is not separated in Japan, unlike in the United States. So professional judges and lay judges jointly decide on both facts and sentencing. And the decision by a simple majority is sufficient, as long as it includes at least 1 professional judge. Okay, and the presiding judge will announce the decision and the reason. In jury trials in the US, jury will not give any reason. Okay, and lay judges are bound by lifelong strict duty of secrecy, although many of them actually give press conferences and provide some limited information. And in 2016, there were about 1,000 decisions by this system, and there were 12 acquittals. And the acquittal rate was 1%. And this, you can compare this with other cases. There were about 58,000 decisions by trial courts, and the acquittal rate was 0.6%. So acquittal rate was slightly higher in saibain trials, lay judge trial. And there is a recent trend, noticeable recent trend, that on the one hand, those who served as lay judges are quite satisfied. They report that they are treated very nicely. Experience was worth spending time. But on the other hand, the abstention rate is increasing. And the rate of declination is also increasing. Therefore, the law is recently amended to exclude cases which are likely to take an exceedingly long time. And the longest time needed so far is 140 days. And good guess is that if the case is likely to take more than a year, probably that case will be excluded. But no case has ever been that long. And so I see some issues. Trials are conducted with an extremely tight schedule. Judges try to finish case according to schedule, which means that they try to reduce number of evidence and witnesses as much as possible. And appeal against the verdict is also a problem. In Japan, both defense lawyer and prosecutor may appeal a trial court decision to the High Court. And there has been a debate whether the High Court or Supreme Court may overturn the decision by the lay judge trial or change the sentence by lay judge trial. Okay. And also, there has been a debate about the impact of the whole system. Liberals wanted to have a side effect, or actually main effect, to improve the criminal investigation in general. But no one knows exactly whether that has happened. And also, defense lawyers have has a disadvantage over against prosecutors, because while prosecutors are working in national organizations on a full-time basis, defense lawyers are not. So there's an imbalance of organizational foundations. And I should finish two more issues in 1 minute. Okay. And so a victim participation system, this was introduced in 2008, 6 months earlier than the introduction of cyber trials. This is a result of a highly successful movement of the organization called National Association of Crime Victims and Surviving Families, so-called NAVS. This organization was organized in 2000 by a former president of one of the largest bar associations in Japan, whose wife was murdered. And this organization was so successful that the organization has immediately attracted attention and support from conservative politicians, Justice Ministry, National Police Agency, and the business community. Time out. Sorry. Give me 1 more minute, maybe 1 or 2 more minutes. Okay. And so this system is applied to crimes with intent, committed with intent, resulted in the death of the victim, rape and indecent act, and so on. So the range of crimes is similar to the range of crimes tried by lay judge system. And the victim, her legal representative, or her attorney make question the witnesses and the defendant and present a closing argument on fact and sentence, virtually as a second prosecutor. So this is very different from victim impact statement in the United States at the sentencing stage. You know, victim representatives participate from the beginning to the end of the system, of the procedure, even presenting final argument, closing argument. Okay, and trial in 2016, 1,400 people participated, and 1,100 were attorneys, and 600 questions of the defendant, and 700 presented closing arguments. And the trials became extremely emotional. And my friend David Johnson described that there were lots of tears in trials with victim participants. And it makes criminal defense extremely difficult. Okay? If you challenge, present too aggressive defense, then lay judges may consider that the defendant is totally unrepentant, so that he or she should be punished more severely. And NAVS has achieved its purposes of increasing punitiveness of punishments and abolish term of limit, and also introduce this victim participation system. And it's going to be dissolved. But there are many other similar victim rights organizations. So they are likely to stay in Japanese criminal justice system. Okay, then I'd like to finish quickly. Criminal justice legislative process. Basic laws, such as amendment of criminal procedure or a penal code, must be first presented to the deliberation by the organization called Legislative Council, Hosei Shingikai. And the Justice Minister prepares a proposal and sends it to the Shingikai Council, and the Council establishes a subcommittee for specific issue. And the subcommittee return a proposal and to the parent council, and the parent council return a report to the Justice Minister. And the Justice Minister discusses the matter with career bureaucrats in Justice Ministry who are prosecutors. And when they agreed on the final proposal, they will send a bill to Cabinet. And the Cabinet will present the bill to the Diet, which has 2 houses. Okay. So there are 2 possibilities. One is a very smooth legislation process. Smooth process can happen when the Justice Minister and bureaucrats, civil prosecutors in the Justice Ministry agreed on the basic policy from the beginning. And the recent amendment of sex crime provisions in penal code is one of those examples. And the council returned the recommendation only with 8 meetings. And the Justice Minister presented a proposal, very detailed proposal at the first meeting. And the conclusion of the council was exactly a slight revisions of the original proposal. But there was another very rough process of legislation. That was the introduction of videotaping of interrogations in Japan. That time, government was not LDP. The government was under the Japan Democratic Party. And so perspectives of Justice Minister, government party, and bureaucrats, prosecutors, were very different about criminal justice. And after a series of cases involving false convictions and prosecutions, JDP Justice Minister decided to establish a special committee under the name of, fancy name, Subcommittee on the Criminal Justice System in the New Era, 新時代の刑事司法. Okay. And but the committee had a large number of members. And those committees are mostly appointed by Justice Ministry officials. And they include large numbers of members, former members or current members of what I call criminal justice establishment, Judiciary, Justice Ministry, and National Police Agency, and punitive conservative victim rights organizations, and plus moderate and conservative law professors who perennially occupy positions there. And deliberation was very slow until the change of the government. Once the government was changed to LDP, they started to work very quickly. And liberals who were appointed by Justice Minister, JDP Justice Minister, were overwhelmed by a majority of conservative members. And the final result was a totally unexpected one. The videotaping of interrogations will be limited to cases which are likely to be decided by cyber trials, which means about 2% of criminal cases. While introducing such limited videotaping, prosecutors and police are now able to bargain with the suspects for providing incriminating information about a third party. So this is called a Japanese style of plea-bargaining. And also, the scope of legalized wiretapping was expanded. So from the perspective of members of criminal justice establishment, criminal justice in a new era meant introduction of plea-bargaining and widening of wiretapping. This is the end result. So we have to be careful that when so-called reforms are introduced in the legislative process like this, those reforms either benefit the criminal justice establishment or amended, modified to benefit criminal justice establishment. So my final question is this one. Fundamental question. Is it always good to have, to increase punishment? Okay. As I told you, criminologists, I think, largely agree that punishment will not rehabilitate. Then what is the, on the other hand, there has been various cases where simply punishments were added or increased. And so the final question is, why do we rely so much on punishment? What purposes those punishments will serve? If rehabilitation is not achievable, then is it deterrence, incapacitation, or retribution, or satisfaction of the victim, or improving, heightening the social awareness? We have to be more carefully discussing these issues. This is my last point. Thank you very much.
Hello, everyone. Thank you for coming. My name is Mari Hirayama. I'm from Hakuoh University, which is in Tochigi. And I'd like to show my gratitude to Kyle and Temple University, and also Miyazawa Sensei for giving me always the great opportunities. Thank you. So today I would like to talk about sex crime in the Saiban Inseido system, and also inquest to prosecution, which is Kensatsu Shinsakai. So as Miyazawa Sensei pointed out, there are many changes in criminal justice system. Our criminal justice system is actually once criticized by one of the most distinguished scholars of criminal procedure as silent pyramid, because it didn't react to many issues. But I think after late 90s, it has become chatty and producing many changes. One is victim inputs, like a victim participation system, and also the biggest one is Saiban Inseido. And also their inquest prosecution, Kensatsu Shinsakai. So Saiban Inseido will be 9 years in May, so in 2 months. And as Miyazawa Sensei pointed out, there are some basic factors of Saiban Inseido. So Saiban in with the professional judge, they decide not only fact-finding, but also sentencing. And they target only a limited number of very severe cases. And this is how the courtroom look like. One of the things I'd like to point out is the side effect after the introduction of the Saiban Inseido, where the defendant sit is different from before they used to. I think that before the introduction, they have to sit here, very quite apart from their defense lawyers. But after the introduction of the lay judge system, now they sit closer to the defense lawyers. So I think it's one of the good changes. So my talk today is the sex crime in Saiban Inseido and the sex crime in Kensatsu Shinsakai. So let me talk, why am I focusing on sex crime cases? Of course, sex crime is always important. It can be triggered to enhance the criminal justice policy for victims and also offenders. Like Megan's Law in the US, sex crime is always a trigger. And I have been seeing the difference between the sentencing for the sex crime after the introduction of Saiban Inseido. So why it's different and how it's different. And also victim issues are more serious there. Sometimes they like the increasing of their sentence, but many victims do not like to face with lay people. So maybe more burdensome for the victims. And also, who becomes lay judges matter. So what if we have more female lay judges, the sentence is different? Or what if we have only male lay judges and only male professional judges? How different will be the sentencing? So any gender difference. And also, lay people's voice impacts on law reform. So are we going to introduce a very radical criminal justice policy like Megan's Law in the US, because now the public are more interested in the sex crime issues? And any penal code reform, yes, it has. Professor Goto will be talking about the penal code reform. But I think behind the penal code reform, the introduction of the Saiban in Seido has played a huge role there. So only 2 or 3% of all criminal trials are tried by the lay judge trials. So I would say between 2,000 and 3,000 cases a year. And sex crime cases, I would say 20% of them are sex crime cases. Indecent assault causing death or injury. Now we changed the name from rape, but now we say forced intercourse. But forced intercourse causing death or injury, robbery in the scene of rape, and also gang rape causing injury or death. Those are the sex crimes tried by the lay judges. So just rape or just indecent assault won't be tried by the lay judge. They are tried by their bench trial, only professional judge trials. So has sentencing changed? So sentencing comparison will be one of my interests, because I would say the impact of the lay judge system, many people will be interested about how the sentencing has been changing, because Japanese lay judges also decide the sentencing. So this is the comparison about what's the most frequent sentencing they are giving. Homicide, maybe, so the red one is the lay judges, maybe broader. Sentencing for attempted homicide, a little bit in a harsher way. Sentence for injury causing death. So this is also a little bit harsher way, but you can say the percentage, the red one is lower. So the most clear impact can be seen in sex crime cases. Sentencing for rape causing injury, and also sentence for indecent assault causing injury. This one, maybe it is hard to see, but I made this table. So indecent assault causing injury cases, the most frequent sentences are toward harsher way after the introduction of the lay judge trials. And my research is I had conducted with the sentencing and also the information on 205 cases after the introduction of the lay judge system, only in sex crime cases. And I counted the ratio, sentencing per sentence asked. And sex crime cases, you see the higher ratio compared with that ratio in general crimes. And also, sentence exceed asked sentence. We say in Japanese, kyukei goe, which happens not very much, but when we see about the sex crime cases, so sentencing exceed sentence asked kyukei goe case, which can be more frequent to see in sex crime cases. And also, sentencing asked is lower than sentence, which is less frequently seen in sex crime cases. So, and my next question is how lay judges, professional judges, victims, and defense lawyers like this tendency, like this trend. I also was focusing on the comments by the lay judges after they are giving the verdict, and which are quite interesting. So one female lay judge say, if this weren't lay judge trials, this sentence would not be given. So they thought their inputs are very important to giving out this sentence. And also another male lay judge say their very positive way of comments. And also, what about the professional judges? The first one is the sentence for sexual crime so far has been too lenient in terms of general sense of people. And the second one is the sentence for sexual crime so far has been too lenient. The lay judge trial should become opportunities to reconsider sentencing for sexual crime from viewpoints of healthy common sense of general people. So my question here is, if professional judges think that way, why they didn't give the harsher sentence before? So I think the professional judges now think the inputs of the lay judge can be a kind of the excuse for them to giving out the sentence which is harsher, so they do not have to be now tied with their precedents so much. They can say, oh, this is what the lay judges want. And what about defense law? Of course, they dislike the lay judge inputs in sex crime cases. So this one is actually the sentence exceed the sentence asked. This is a rape-causing injury case. And this defense lawyer commented that lay judges were so affected by the statements of victim's family, which lead to this severe sentence. What about the victims? So this is their comments by the father whose 6-year-old girl was victimized for their indecent assault causing injury cases. And this father said the lay judge system will be the opportunity to make a new sentencing guideline for sex crime. By the way, in Japan, we do not have any sentencing guideline. But I think this father expect the input of the lay judge to give out their sentence, which is more preferable by the victims. But speaking about the victims, I think it can go both ways. Maybe victim will welcome the increasing sentence, but that can be more burdensome for victims because now they have to face with lay people. And this is about a depiction of the victim who gave a statement in the lay judge trials. And we can see how she had to cover up. She didn't want to be seen by the lay people. So that can be, the lay judge trial can go both ways for victims. So victims do not want lay judge trials. So what the prosecutor can do? So again, if the sex crime causing death or injury, those crimes can be tried by the lay judge. So what the prosecutor can or may be doing is they just drop the part of the crime. So they prosecute their crime of coerced intercourse, I mean the rape causing death or injury case, just rape, so that the case won't have to be heard by the lay judges. So one hypothesis is maybe if that is true, the kisoritsu indictment rate dropped in indecent assault causing death or injury case or rape causing death or injury case. But on the other hand, rape and indecent assault, those kisoritsu indictment could be rising. So this is what I have found out. So indictment rate in sex crime cases has been dropped in general. So my hypothesis was wrong. So the indictment rate for the sex crime cases has dropped after the introduction of the sex crime cases in general, not only in sex crime causing injury or death cases. Sorry. And any impacts on law reform? Yes, it is, because since last July, we have the reformed penal code. So there are some changes. And the second part is about the Kensatsu Shinsakai, the inquest of prosecution. And I prepared some flowchart in your handout. So now you will see how when the case is reviewed by the commissions, how the case is goes through the review. And as Miyazawa sensei pointed out, when the case reached in the second tier review, the commission can give out indictment vote which will be reaching to the mandatory prosecution. And this is some numbers. They reviewed 2,000 some cases a year, and the first phase indictment is proper. We call in Japanese kiso souto giketsu. It's just 4. And the case which reached to the second phase is just 3, so very small number. And 3 out of 3, only 1 case reached to indictment vote. So the Kensatsu Shinsakai was introduced in 2009, the same time we introduced the lay judge system. And there has been so far 9 cases, 9 mandatory cases. And out of 9, 2 cases are got into guilty verdict. And this 9th one can be very interesting to many people because this is a typical case. And I think sometime soon in April, there will be the 5th date of the trial. And what I'd like to focus is this 7th one. This is only the 6 crime cases, which voted for indictment vote by the commissions. So this is 18 years old girl was raped by their golf instructor. He was the mentor for her, and she couldn't resist. And the perpetrator clearly took advantage of the relationship, those power relationship. And but the prosecutor didn't indict the perpetrator. So the victim brought to their commission, and the commission twice they voted for this case must be indicted. But the court found the perpetrator not guilty at the first trial, second trial not guilty, and they just dismissed the appeal. The Supreme Court dismissed the appeal. So the verdict was finalized. And my interest is, what if this case are here heard by the lay judge trials? So this is, remember, this is just a rape case. So I shouldn't say the rape, just rape case. It's the rape case, it didn't cause injury or death. So that case was heard by only professional judges. But what if this case are heard by lay people? So lay people input in prosecution and lay people input in trial. That can be different. But that was not the case. So 9 cases so far. So this is a very, very famous case about the Kensatsu Shinsakai and Ito Shiori-san. And the victim of quasi-rape, we have a very weird category of crime which says quasi-rape, I think, which is very strange though. So she asked the commission to review her case, but as you know, the commission decided the case, the non-indictment is proper. Fukiso souto giketsu. So basically the commission said, okay, prosecutor, you were right that the decision you didn't indict the case, we think you are right. But the biggest problem is the procedure is very unclear and unseen. So that's why she published a book titled The Black Box. Many things can be very difficult to be seen, even by the reviewer, the person who is in the big interest about the case, right? And Shiori-san filed a civil lawsuit, so we are very much interested in how the case will be going on. And Jungokan, the quasi-rape, is very, very weird category of crime. So the perpetrator took advantage of the condition that the victim is unconscious. And but I would say these category of crimes are more difficult case to be established because so that is another difficulty about the Shiori-san's case, I think. Okay, so further research. Let me go to the conclusion. So why sentencing for sex crime has been increasing in lay judge trials? I think the lay people's input has been playing a big role to change the sentencing. And I also calculate the ratio with the gender issue. And now we have more female lay judges, of course, in sex crime cases. And I think that can be one of the impacts in changing their sentencing. And also this one, commissions for inquest over prosecution, whether it is democracy and justice or how is their standard of prosecutions. So that the commissions thinks the meaning of the justice or trial is different after the introduction of the commission. So they ask and they want the justice for citizens. So I think the role of the trials are different after the introduction of the commissions. And also, let me go this one. So again, there has been no cases which have dual lay participation, which mean mandatory prosecution by the commission and the case are heard by the lay judge. We haven't had any case so far, but I'm very much interested to see how those dual lay participation can be seen in this effect. And the last three, impacts on legislation of penal code reform. We have now the new Hakuoh, penal code. And I think one of the aspects is because of the penal code reform, changes in law can be lead to the perception or maybe change in the public. So this is quite interesting. This is like a hotline by Kyoto Prefectural Police for the sex crime cases. Before they say, ladies 110番, so which sounds like we are helping for only ladies, right? But the penal code reform, one of the very big and important changes, now the victims of rape can be male. So they change the name of their hotline and they said Hato-san. So that can be the message that we are helping, of course, not only the female victims, but also the male victims. So I would say the introduction of the lay judge system changed many things, sentence, and also the the legislation, and also I hope more change in perception in the public can be seen in the future. Thank you very much for your attention.
So good evening, everyone. My name is Hiroko Goto. I'm a professor of law at Chiba University Law School. Today, I will focus on the last year reform of the Japanese sex crime law. And the Professor Miyazawa and the Professor Hirayama mentioned about how big change happened. I also welcome this kind of change happen, and in criminal procedural law, and also I'm very welcome the penal code changed. But during their speech, and I have been thinking about Shiori Ito, and I had a very good time in New York and this March. And so then her case rejected by prosecutor, and her case rejected by the inquest of the prosecution. And this procedure, criminal procedure, is not for her. So I know the many victims and survivors who couldn't reach this process. So, but of course, the system is there, and the system is waiting for her and him. But there are many barriers to reach that level. And so then I'm a little bit frustrated. So how the Japanese criminal justice system is become better and better, but how many victim survivors are crying even after Cyber system introduced or the new law introduced? I don't know how to do that. It's okay. Today I will talk about the last year reform mainly, and also that I want to share how many challenges remains. And the time back to the before the 1945, and before the World War II, Japan had no fully discriminated under the patriarchal Meiji Constitution. Women has no right to vote, no right to inheritance, no right to make contract without husband consent, and no right to enjoy the higher education. ES family system, patriarchal family system, the basic fundamental, the principle of the family law. Oh, sorry. And this is the Constitution you may know. The Article 14 and Article 24 is a very important relating to the gender issues. And some laws were amended, but some law did not. I want to focus on that the penal code is one law did not changed. And also the clear legal discrimination clauses in the family law were eliminated from Japanese law. And the new family law was enacted after the new constitution was introduced. And not only, but the adultery statute was removed from Japanese criminal law in 1947 because it said that married women who had sexual intercourse with a man should be punished. Only married women. Married men is okay to have sexual intercourse with unmarried women. So, and also this is a very, very discriminatory. And that's why we abolished this statute. But also the South Korea had the same penal code, and also that they changed recently. So, and however, criminal law did not amended totally. This means we are still using a very old and gender non-friendly criminal law even now. And do you know that when the Japanese criminal law was introduced, 1907, could you raise your hand if the have a memory of the 1907? Nobody there. Of course, nobody. And it was 110 years ago. Of course, someone still live in this earth, but it's very difficult to find that kind of person who have memory is 110 years ago. And also that you could imagine that and no female members in imperial diet. Of course, no universal suffrage, and the women's suffrage and equal opportunity for higher education is after the World War II. And I always thinking these things, why we could keep this kind of criminal law until now. Of course, some changes happened. The 1947 adultery provision was deleted. And also that relating to the rape, and Professor Hirayama also mentioned, a gang rape provision was introduced. But unfortunately, gang rape provision was eliminated last year because you see that the gang rape provision, the minimum sentence is 4 years and over imprisonment. And the minimum sentence, also that in the 2004, minimum penalty rape was changed. Before that, rape, the minimum penalty was 2 years imprisonment, and then become 3 years imprisonment. And make penalty harsher, and also the murder, 3 years imprisonment and for minimum sentence, and 5 years imprisonment for minimum sentence. And also the another things happened, it's relating to trafficking in person. And also that why last year the law reform happened after 110 years. So of course, in the 2000s, gender equality basic plan is introduced, and the inside of gender equality basic plan, always targeting the sex law reform should be introduced. And also the United Nations Convention on Rights of the Child, and also the CEDAW, repeatedly recommended sex crime reform. But we have Japanese government ignore that kind of the, pressure from outside. And also that the 2012 Cabinet Office Gender Equality Bureau made some report about the sex crime law reform. But it is not enough. As Professor Miyazawa mentioned, also she is a Minister of Justice in that time, 2014, Midori Matsushima. It's sometimes difficult to remember the name of the Minister of Justice because so many changes happened recently. But you should remember her name because of her, the last year change happened. And also she stressed the necessity of the sex crime law reform in her first press conference. Because of her, the Ministry of Justice started a special committee for sex crime law reform. That is a very big step to change the sex crime law. And also inside the special committee, a comprehensive discussion on sex crime law reform happened. The abolishment of the statute of the complaints and the raise of legal penalty under limit and the reconsider of legal term with through assault or intimidation and raise of age of sexual consent. The Japanese sexual consent age is 13 years old. Yeah, it means that under the 13 years old means 12 years old. The 12 years elementary school girls. 13 years should be the middle school age, but 13 is too low, I think. And the rape relating to the rape statute, victims should be both male and female. Reconsider of the legal term on the sexual conduct. Rape, rape means that only the intercourse and intercourse only to using the object or fellatio. And the temporary suspension of the limitation of the prosecution, and introduce new provision on using power or status, and using the new provision on the marital rape provision. These all topics discussed under the special committee. Then the reform goes to the Legislative Council of Ministry of Justice. This is very important, as the Professor Miyazawa mentioned. But you see that only this kind of things happened. As you see that no. Oh, sorry. Okay. Yeah, these elements that should be considered, but only few things alive to the Legislative Council of Ministry of Justice. And only the complement, the statute is abolished, and also the rape, neutralize the rape victim and the variation of rape, and rape by parents or the guardians, and the minimum penalty was raised, and the robbery and rape is combined together. And these only the things became a law last year. And the rape statute, I said rape, but Professor Hirayama mentioned the name is changed, forced intercourse. But I would like to say rape as used to be. And before a male sexual organ penetrates and into the female sexual organ, this is only the rape, I mean the intercourse by a male was a rape. But after that, not only the intercourse to the female sexual organ, and also the other organs also are included. And also the minimum penalty became 5 years imprisonment. It's that minimum penalty is the first and the 2 years, and also the 2004 became 3 years, now 5 years imprisonment. And also that the sex crime, the victim complains is necessary to prosecute, but this is excluded, eliminated. And also the sexual abuse by parents or guardians became a special new statute. Under the age of 18, consent has no effect to establish a sex crime. And also that in the diet, the supplementary resolution is both House of the Representatives and the Councils we got. This is a very interesting. Usually, this supplementary resolution heading targeting to the government only, but in that time, the Supreme Court also involved. So this means that there are many things that get involved, but the Supreme Court, the sentencing or Supreme Court attitude is not appropriate for the victims survivors for sex crime. And we have a lot of challenges. And also the male sex organ is centered. Penis is centered in our law. And how about the case of lesbian couple? They have no male sex organ. This means that there's no rape case happen between the lesbian couple. And also the assault intimidation requirement remains. This is a big debate and a big criticize that happened. The victim's sexual autonomy is not prioritized in our law. And also the sexual consent is too low under the 13 years old. And also that I want to point out, the criminal justice system is not gender neutral. Rape myth is overwhelmed inside the criminal justice system. Even the Supreme Court judges say that the sex crime victim survivor should resist, run away, ask for help. If they didn't, the judges couldn't believe her testimony. And also the unconscious gender biases with in criminal justice system are so strong. Practice should be reconsidered, and education to judges, prosecutors, and lawyers should be essential. How to educate the legal professions? That's a very good question and a difficult question. I'm teaching the gender law in my law school. But the gender and law is marginalized. And also it's very difficult to breaking down silo. And also that it is impossible to use the same statute for different interpretation. So used to be that 110 years ago, the women's justice system should be the main reason for rape. But now everyone says that right to sexual determination, but the same statute. So it's very difficult to say that the different interpretation using the same statute. And also the terminology in the statutes were not changed. Also the Professor Hirayama mentioned the quasi-forcible indecent or quasi-rape. It's so weird. I agree that. And also what is the forcible indecency? The indecency is a common terminology with pornography. So finally, I want to say that the lessons from Miss Shiori Ito case. Her voice has not fully heard in the criminal justice system. And also that in her case, and she will come next month, and coming out to bring a huge risk in Japan. She have to move to United Kingdom. And the one-stop center for victim survivors is dysfunctional. And rape myth is overwhelmed in the Japanese society. Date rape is not rape in Japanese society, Japanese context. And this is the one-stop center I'm related to. It's the Chiba Support Center for Sexual Assault. We have this kind of system, but she didn't. It didn't help. And also that this slide is happened 2 weeks ago in New York. And also the Shiori said that she started new movement, not me too, we too. She said that in Japanese context, Me Too is not appropriate because we couldn't say by themselves, but we is so easier to say something. So maybe she will come next month, and so I'm very happy to be with her in New York. And thank you.
Hi, thank you, panelists, for the wonderful presentations. My name is Michelle. I am from South Korea. I came to Tokyo 1.5 years ago now. And then I was quite shocked when I came here and then make Japanese friends, because I was shocked by how backward Japan is in terms of gender equality. I thought South Korea was pretty backward, but when I came here, I could really feel the gender gap, and I was very surprised. So Me Too, my question is, Me Too is spreading like a wildfire in Korea, as you well know, right? And it's like killing the perpetrator by because so many people are supporting the campaign, and so many victims have spoken up. So some of the perpetrator actually felt the pressure and they committed suicide. So I recently got a question by my friend who asked me, oh, so Michelle, I know you have been in both countries. I see how Me Too has grown really big in South Korea, but why is Japan so quiet? Why there is this huge difference between these two countries? So I want to ask you, why you think that is the case?
Yeah, many people ask me the same question. Also, the BBC came, why the Me Too movement is not overspread in Japan. And I'm thinking so many reasons the Me Too movement is very difficult in Japan. And maybe the one big element should be the old our criminal law, and also this is my hypothesis. The one is we know the law is very old, and so the unconscious gender biases lying under the laws. And also we see how law implemented, and also not only the implementation, but also the law itself saw gender biases. And this kind of moved overspread in this nation, in Japan. That this is one reason. And also the many people also that see the what happened if I say something, and like a theory, and the theory criticized the many ways. And you know that, and in the press conference, and she came, she did last year, first one, she wearing the shirts, and she buttoned, not buttoned, buttoned, it makes sense, and unbuttoned two unbuttoned. And so in the SNS, and say that you should be the victim and survivor. Victim survivor should be wear the so tight the tight outfit. It is not good for wearing this kind of outfit as the victim survivor of the sex crime. And this kind of the criticized easily heard by the victim survivors, and so this is discourage them to speak out. Even I had a lot of experience by the sexually, maybe sexual harassment, but it's very difficult to say openly even now. And because maybe some criticize and maybe will be expected, should be expected. And that kind of mood is overwhelmed in this society. This is one reason, the two, my hypothesis. And also I want to mention that at the theory case, and I'm assuming that another victim should be there. But if another victim speak out, the theory case will be treated differently. But it's never happened. And this is one big example compared to United States or United Kingdom, and also the South Korea. A lot of pressure. If I say something, we criticize, and our career was ruined. That kind of thing, there's no hope if I say something. Nobody heard the victim survivors' voices in Japan. Because of that, the Me Too movement is not popular in Japan.
Thank you for your question. I think when we focus about registration, I think the South Korea is more open to change many laws. But as Professor Goto says, our registration in the law are very, very conservative in Japan. So that's one of the reasons why it has been so lenient and slow to react to victim issues. And I would point out also the media, role of media, because speaking about the Shiori Ito-san's conference, one newspaper mentioned that one young lady entered the room with the low-cut outfit. So what it has to do with the content of her issue? So that's the comments by the newspaper. Can you believe that? So that's, I think the media's role has been very, playing a big role about the gender-biased situation in society.
Thank you all very much. My name is John Myers. I'm teaching this semester at TUJ Japan at the law school. I'm interested in the data. What I didn't hear was, I think I have a general understanding that about half or so of complaints by victims of sexual assault are prosecuted, only half. So the question is whether there's data about how many complaints there are, why they are dismissed, and what happens up the chain. That has been difficult for me to find. Thank you.
I'm using statistics published by the Justice Ministry. So there's a fundamental question about the, truthfulness of this statistics, but because there's no other public information, I use it. So in 2016, there were 1,100 complaints for rape, and 370 complaints resulted in prosecution. And 50 complaints were rejected. Were treated as a suspended prosecution. And 606 complaints resulted in non-prosecution for other reasons. And the other reasons include, I think I briefly mentioned this. 310 cases were judged having insufficient evidence. Because under the current statute, penal code, subjective elements of both the defendant and the victim are the most important elements for proving guilt. But how can you get such information from objective information? So, this is fundamental difficulty of sex offenses in Japan. And then 214 cases were rejected by prosecutor because complaints was withdrawn. So, and also in 78 cases were dropped because of statute of limitation. So if you look at those reasons, you'll understand the difficulty of prosecuting sex offenses in Japan.
May I ask a follow-up? Is anybody doing any work that you know of to determine what underlies the prosecutor's decisions in 30% of the cases to say not enough evidence when the victim has obviously come in and said he did this to me? Does anybody look at that at all, or is it just acceptance of the government statistic?
Yeah, so as I said, this is totally statistics published by the Justice Ministry, which means statistics prepared by prosecutors. So your question is extremely important, but in order to find out, you have to interview prosecutors, but nobody has done such research in Japan.
Do you think it could be done?
I don't think so, but my old student, David Johnson, who is now teaching at the University of Hawaii, did observational study of prosecutors under my guidance in Kobe about 20 years ago. But he interviewed and conducted questionnaire surveys of prosecutors to find out their reasons to suspend prosecution. But the results were, I think, too good to believe. For instance, the largest category of answer was that they were seriously interested in rehabilitation of criminals. Therefore, they did not want to send criminals who did not deserve punishment. But the question is whether each defendant deserved punishment or did not deserve punishment. You have to be in the same place to find out real reasons of prosecutors for making such decisions. In that sense, it's important to have procedures like inquest of prosecution and quasi-prosecution system. Okay.
Thank you.
My name is Jake Adelstein. I'm telling you so when I send you emails, you know who I am. Because I had an interesting question. The Shiorito case I've been following for months. I think I was the first journalist to write about it in English. I met her several times. And in that case, remember, there was actually a warrant for arrest issued for rape charges, and the head of the police department dealing with that, who was a political friend of Prime Minister Abe, had the rape warrant rescinded, which is unprecedented in Japan. That's a whole problem of police corruption, ostensibly. But more than that, you talk about the prosecution only prosecuting 50% of the cases. But I have heard from police officer after police officer, and in Shiori's experience, and from victims as well, that when they go to the police won't even take their complaint, that they are actively discouraged from filing charges and turned away. And as a matter of fact, I can't even find data on how many people go to the police and how many of those cases are actually turned into a criminal complaint and then sent to the prosecutors. So in your opinion, why are the police so reluctant to even deal with sexual assault victims, take down their complaint, or investigate these crimes?
I think the one reason is the prosecutors. And also the prosecutor have only the right to indict. And also if I have many, not many, but I have some police officers, they are very concerned about this kind of cases. But they always complain that if we did some the investigation, and but the prosecutor never ever indict. And also that this kind of circle happens a lot. And so it's easily understand, and the police officer the withdrawn the cases is very reluctant to deal with the cases. And also that maybe the rape case used to be is a complaint is needed. And also that they are very worrying about once the complaint was over, was it? Yes, finished, and so then they have no right to investigate or no right to prosecute. And also that you know that the lawyers and the perpetrators, defendant, try to get some withdraw the complaint. And I'm very have a hope, and the last year the reform and no complaint is needed to indict the cases, and this means that the defense lawyers' technique will be changed. Because there used to be is withdrawal of the complaint is only the one big triumph for them, but this now they couldn't this kind of strategy, and so one big reason is the prosecution, and also that they met as victim and survivors the first time. And so that's why, and also that they trained in some level, and they are very sympathy. They have a very empathy to the victim and survivors, and also that in the case of Shiori is because of that it's a real rape case, is not the stranger rape case. The Japanese police officers and also the prosecutor have no skill to prosecute the date rape case. If you check the court decision, many cases, maybe the underage of the 13, the kids case, or the stranger case, or gang rape case. And that if the perpetrator is acquaintance or the boyfriend or husband, that they have no skill to show collecting evidence or the indict. That's a very big reason the happened to theory case.
Okay, so the reasons why the police are reluctant to the sex crime victims. If I try to speak for the police, though I don't want to, I think one of the reasons is they try to make it sure that the victims can endure the procedure afterwards, because as Professor Goto says, before the penal code reform, they needed their complaints from the victim. So they have to make it sure and ask the same question again and again. So those attitude made the victim give up. And also I would say the real reason or the bigger reason is their gender biased and inadequate understanding about the victims. So sometimes the victim's memory, they just gone, and because of so under big fear, and they couldn't speak well about what happened. And the police the police just think that, or victims are not telling truth, or victims doesn't remember well. Those kind of inadequate understanding about the victim situation, I would say, made the victim, the police reluctant or seems unwilling to respond to the police.
Same question. I think then we'll eventually go to the judiciary. Attitudes of judges against, regarding sex offenses, and the police hesitate to investigate cases which are not likely to be indicted, and the prosecutors are not willing to prosecute cases which are not likely to produce a conviction. So ultimately, the issue is how judges are thinking about gender issues and sex offenses and so on. Again, I think it will take a long time to change that judicial attitude. But on the other hand, we should recognize a kind of dilemma. In Japan, in order to get conviction, you don't need to get a unanimous decision like jury verdict in the United States. Japanese decisions are based on simple majority. And so in bench trials, if the prosecutor can persuade 2 judges, he can get conviction. And in cyber trials, if the prosecutor can persuade 5 members, including at least 1 judge, he could get conviction, which means that a standard of proof in Japanese trials in general, I'm not talking about sex offenses, but generally speaking, standard of proof required to prosecutor is much lower than that required for American prosecutors. Japanese prosecutors are working in a kind of heaven for them to get a conviction. That's why they get the conviction rate of nearly 100%. But sex offenses in one of the few categories where prosecutors have difficulty, because prosecutors need cooperation from the victim, who is quite hesitant naturally to speak in an open court. Therefore, I'm quite skeptical about the abolition of requirement of complaint by the current recent amendment, because still, in order to present evidence, you have to have a witness, which is, of course, victim. Therefore, I think the difficulty for prosecutors to get a conviction, even in a very favorable general condition in Japanese criminal trials, will continue to exist.
A quick follow-up question for you, Professor Miyazawa. Is there any statistics on the number of complaints that actually result in arrest for sexual assault cases at the police level?
Yeah, that is a question. Maybe 10 years ago, when stalker cases became serious problems, a national police agency virtually ordered local police officers to accept all complaints as legitimate complaints. But then the number of reported cases has started to decline, because police returned, I think, to traditional way of handling cases, which means that they will not accept reports of cases, complaints of cases which are not likely to produce conviction.
Thank you very much.
Hi, my name is Sahil. I have a question regarding lay judges. You told in the presentation that they are appointed from local voters. Like, could you explain in brief, like, what are the criteria on how they are selected? Like, are they selected at random, or is there some certain criteria? And I actually have a second question, and it is, I got the feel that the Japanese justice system, it places less importance on facts and evidence, and more on like emotional side of the argument and the impact on society of their judgments. So, like, what do you think about it?
So the lay judge will be selected from the voters list. So they got a letter, I think, in November every year. And they are questionnaire that if any reason you will say you should be waived from their role of the lay judge. They say yes, like I'm over 70 or I'm sick or something like that, and then they return the letter, and then every time the lay judge tried by the lay judge crime happened, and when the lay judge trial happens at the district court level, they summoned those candidate lay judges. I would say 15 to 100 per case, which depends on the size or how their case are serious or not. And then they do like a voir dire, their selection process for those candidate lay judges. And as Professor Miyazawa says, the prosecutors and the defense lawyers, they have the right to challenge the peremptory challenge and also the challenge with cause. But the difference from their selection process in the US is Japanese people like lottery. So the court used lottery to select the very last numbers of their lay judges. So after exercising the challenges both by defense lawyers and prosecutors, there are certain numbers remain, right? And then court used the lottery to choose 6 lay judges and maybe plus 1 or 2 alternate lay judges. So that's the procedure. And the second question about the emotion, right? So that you said the Japanese justice system is, you think is more emotional?
Like, I want to know if my conclusion was accurate or inaccurate. So, like, what are your thoughts about it?
I have to say, after the introduction of the victim participation system, some sentence can be seen as emotional. And one of the problems is in Japanese criminal procedure, we do not divide the fact-finding phase and also the sentencing phase. I know that the US and the UK, you have the victim impact statements, but you only apply to the sentencing phase. But in Japan, as we do not divide the fact-finding and the sentencing phase clearly, and there we introduce the victim participation or a victim impact statement. So the victim input, I would say, can impact on both on fact-finding and sentencing.
Okay. Yeah, I'd like to add a few words about that issue of emotionality of Japanese criminal cases. In Japan, all cases must be tried in open courts, whether the defendant admitted guilt or not, which means that in most cases, what defense lawyers will do is to try to reduce sentence rather than to argue that the client is innocent. Therefore, emotional elements of the victim and defendant is very important in order to persuade the professional judges and the lay judges to get lenient sentence. And also, in investigation, if you have only a confession as evidence, you may not convict the defendant. But the common practice is still that police will first try to get confession. Only after getting a confession, they will start collecting other evidence, physical evidence, and so on. Therefore, even at the investigation stage, emotional element or subjective element is still important in Japanese criminal justice.
Okay, so about lay judges selection, so is it like truly random, or are there like some general characteristics that you would? Some general characteristics that you think?
So randomly selected from the voters list. Yeah.
It's totally random. So everyone, we're obligated to leave here at actually 9 o'clock, but we'll run a little late, but if we could keep the questions and answers relatively brief.
This should be,
questioners.
yeah. This should be quite short or easy to answer, I hope. My name is Gavin Gray. I'm an associate professor at Tsuda University's College of Policy Studies. And this is following up a little bit from what was said earlier about the oversight of the prosecutors and the police. So last year, I think there was 42 recognized victims of human trafficking in Japan. 15 of these were foreign people. And if any of us went to Roppongi tonight, I'm sure we can identify much more obvious victims of human trafficking in Japan. And I know part of it is the difficulty of prosecuting these cases and investigating them. And I'm sure there's a lot of diligent police, but I'm a little bit cynical that maybe elements like blaming the victim or prioritizing certain crimes like human trafficking and rape at a lower level might have some influence or institutional prevalence among the police or the prosecutors. So if we can't trust those institutions to watch over themselves, perhaps civic society needs to play a stronger role. I know in terms of human trafficking, there's a group called Lighthouse that does good work in Tokyo. But I'm just wondering, from your knowledge, are there any other NPOs in Japan that do good work in these areas? That's all.
And then we're going to ask those questions together if you could.
Oh, sorry. I didn't realize that.
My name is Kurt Sieber. I'm an associate member at the Foreign Correspondents Club, and I attended the press conference by Shiorito, I think it was in December last year. To keep it short, I mean, there are really two different points, and I'm almost tempted to say it's a little bit like Moritomo. There is on one side, whether there was a crime, and if you tell us that a date rape is never a rape in Japan, well, there is no case except if the girl has been drugged during the dinner there. So that's one thing. The other thing is, as was mentioned, the police were waiting at Narita airport for Yamaguchi to arrest him, and there was an arrest warrant, and that was from some higher authority was suddenly cancelled just moments before he arrived. So again, here comes the Deus ex machina somewhere in Kazumi Gaseki, who has called off this arrest because, well, and again, there is no proof of that. And if we go by Sagawa standards, there will never be any proof. Yes, what really happened, nobody knows. So, but my question, to make it short, is there any follow-up on the civil suit which was filed, I think, in December? Do you have any feedback on what happened there? Thank you.
Thank you for your presentations. It's been very informative. I work for the British Embassy and support rape victims, so I have joined their journey from police station right through to trial, so I understand in some way how awful that can be. My questions, well, we of course welcome the changes in the rape law. I just want to understand a little bit why the age of consent and specifically the intimidation wasn't changed, and if you think that that will change, and is there a big move to change that in the future? Thank you.
Hello, I just had a question. You mentioned before that media bias plays a large role in how society views some of these cases, and I was wondering, do you feel that Article 21 of the Japanese Constitution regarding censorship needs to be maintained as it is, or do you think that also is in need of reform? Thank you.
You mentioned about human trafficking. So, and I have also I know the Lighthouse and doing a very good job and related to the human trafficking, and also that the case of Japanese girls human trafficking is a JK business or other things, and also that the Korobo. The Yumeno Nito Yumeno also doing a very good job and working with the girls and who are run away from home, and also they have no place to stay, and also that the human trafficking is also also the some NGOs and might get involved helping the people, the victim, the survivors, human trafficking cases. And relating to the theory case, and I watched the press conference video. So, and you say that the two reasons why the press conference didn't have before, and I understand what you say, and but also the Shuri case is a kind of the may have another reason, and it's a little bit difficult, different from usually ordinary cases, but I love to believe in her testimony, and also that I have a little knowledge about the civil case, and it's happened last December, and also that they still continuing, but I never, I have no the new information about that, but the Shuri, now Shuri is staying in the United Kingdom and London, and so then she, if the new the thing happened, she should be come back to Japan. Also, maybe she, according to her the appearance in Japan, maybe the last session should be the December. The no session it's never happened during that time. Also that maybe the April will be expect another session for civil trial.
So let me quickly talk about the civil organization. I don't know any civil organization regarding the human trafficking, but I'd say the reason why we have so little those organizations is I think the public in general have the huge trust in authority, and which makes it difficult to create the many organizations like they're helping victims, and also that's right. That's right. Yeah, I do agree that. Yeah, and also about the constitutional issue and the media issue. You said your question is whether the constitution should be amended. The guy with the hat, the gentleman. So you said the constitution, whether speaking about the media bias, we have to change the constitution. That's your question? Yeah, I don't think so. But I'd say that Shiori-san made the conference only for Gaikokujin Kisha Kyokai, right? The foreign conference. And the Japanese media didn't show much interest to listen to her. So I think so maybe the biased, the reporter or biased media can exist, of course. They are protected by the constitution. But also the other side, media, the support Saori and support the various opinions, that we lack in Japan. That's my opinion.
Relating to the age of consent, okay. But we have no hope to change the age of the consent. Yeah, and also the highly ranking the Minister of Justice people say that it's very difficult to change because the why 13, why 14, why 15, it's very difficult to say that. Because of that, they have no intention to change. Well, it's not good.
I agree with Hirayama-san that censorship is no answer to change public perceptions about the issue and media ignorance. And because censorship can be used by the government for other purposes. Abe administration has been already censoring media to change critical reports. So what we need is civil society's own effort to raise issues and educate young people and so on. And there's a international human rights organization called Human Rights Now, where I used to be the board member. And I think it's interested in human trafficking. But the question is, as someone already said, the question is a lack of organizations, larger organizations. And this applies to Shiori-san's movement too. We do not have national organization involving a larger number of victims of sex offenses. I think that is a major issue for the next step of any movement in this area.
Thank you so much. Hirayama-san, Goto-san, and Miyazawa-san, we really thank you for the time. And to the extent that Japan is going to change on these issues, it'll come in part through the good work that you're doing. So everyone, this will be broadcast or published on our YouTube channel in a couple of weeks. I have a very quick announcement. We have an upcoming lecture on next week on Monday, April 2nd, Historical Japan in the 21st Century Pacific Maritime World. And then on Thursday, April 5th, Sanctions, Geopolitical Tools in a Volatile World. If you could leave your Meishu with us, we'll get you on the mailing list. But once again, I want to thank the panelists for coming out and teaching us about this.